Welcome to a presentation on what is the Human Rights Bureau. The Human Rights Bureau is the state agency charged with enforcement of the Montana Human Rights Act and the Governmental Code of Fair Practices. Through a contract with the federal government, the Bureau also processes employment discrimination claims filed under Title VII of the Human Rights Act of 1964, the Americans with Disabilities Act, and the Age Discrimination in Employment Act. We are the first step in a multi-level administrative process that handles complaints of discrimination. Someone who is considering suing for discrimination must exhaust the administrative process before a court will hear their case. The Bureau's main function is to conduct independent and neutral investigations into complaints of discrimination. It is important to understand that the Bureau does not get to turn away a complaint that is filed. We are obligated by statute to conduct an investigation. Complaints come to our Bureau in three ways. First, the Bureau's intake process, which is an hour-long telephone appointment with an investigator to discuss whether or not a caller's situation falls within the laws enforced by the Bureau. Second, a self-drafted complaint. Or third, an attorney-drafted complaint. The Bureau also provides mediation services, which are voluntary and confidential. Lastly, the Bureau offers education to the public, including employers, employees, students, tenants, housing providers, and other interested parties throughout the state. This is a preventative effort to further awareness of non-discrimination laws. The Bureau is a neutral entity. It does not represent charging parties, nor does it defend respondents. The Bureau's fidelity is to the law it is charged to enforce. The Bureau averages about 5,000 calls each year. Our front office staff spend a lot of time working with these callers to explain the function of the Bureau and provide information. If a caller expresses he or she has experienced a circumstance that falls within the anti-discrimination laws enforced by the Bureau, the caller will be scheduled for an intake appointment with an investigator or given information on how to self-draft and file a complaint if they prefer. The Bureau's investigators conduct approximately 1,000 intakes each year. Of those intakes, 500 are drafted into complaints of discrimination, which are then sent to the caller for consideration. It is the caller's decision and responsibility whether or not to file the complaint drafted by the Bureau. Once a complaint is received by the Bureau for filing, the Bureau is obligated to investigate the complaint. As mentioned previously, the Human Rights Bureau is the first step in the administrative process, and we are statutorily obligated to conduct an investigation into complaints filed with our Bureau. Our investigations are informal, which means we don't follow the rules of evidence or conduct depositions like you would see in more formal settings. Instead, we go through the options shown on this slide to conduct our investigations. We interview the parties involved in the complaint and witnesses. If resources allow and the case would benefit from a site visit, that is something we do occasionally also. Of course, we review all relevant documents such as policies, personnel files, and disciplinary write-ups. The Bureau makes it a point to ask respondents for comparative data in almost all of its cases. Comparative data will tell the investigator how other employees inside and outside of the protected class at issue have been treated in similar circumstances. And lastly, there may be times that legal or other research is needed to investigate a case thoroughly. When determining whether or not there is reasonable cause to believe discrimination occurred, the standard of review the Bureau uses is a preponderance of the evidence. This means when weighing the evidence, it is more likely than not, or 51% likely, that discrimination occurred in order for the investigator to reach a cause finding. On average, an investigation takes approximately 20 hours to complete. Some may take longer and others may take a lot less time to finish up. Here you see the bottom half of a flow chart the Bureau uses to help the parties understand the life of a complaint and the administrative process. At this stage, a complaint has been investigated and there has been either a finding of reasonable cause or no reasonable cause to believe discrimination occurred. If the Bureau determines there is no reasonable cause, the charging party can either go directly to district court and file a suit, or he or she can object to the Bureau's decision to the Human Rights Commission. The Human Rights Commission is comprised of 5 commissioners appointed by the Governor of Montana. If the Commission affirms the Bureau's no-cause finding, the charging party can file in district court. If the Commission sustains the charging party's objection, the case will go to the Office of Administrative Hearings for a contested case proceeding. If the Bureau determines there is reasonable cause to believe discrimination occurred after investigating a case will then go into a period of conciliation, which is a chance for the parties to reach a voluntary settlement. If the parties settle, the case stops there and is closed. If the parties cannot reach a settlement, then the case goes to the Office of Administrative Hearings for a contested case proceeding. If the case is sent to the Office of Administrative Hearings for a hearing, either by the Commission sustaining an objection or by the Bureau finding cause, either side can appeal the Office of Administrative Hearings hearing officer decision to the Commission. The Commission is the final level of the administrative process for complaints of unlawful discrimination for the state. The Commission's role is to sit in independent judgment of the work of the Human Rights Bureau and Hearings Bureau by conducting quarterly hearings on objections and appeals. If you find yourself inside one of these investigations, we do have some practical tips for you. First, understand the timelines. The Bureau only has 180 days to conduct an investigation once filed, and less for housing cases, which is not a lot of time given our investigators' current caseloads. Second, if you are a charging party, understand that we only investigate what is written in your complaint, so it is a good idea to understand your complaint. Third, if you are a respondent, understand what your defense to the complaint is so that you can share that with your investigator. Fourth, be truthful and straightforward with your investigator. This seems obvious, but it's a good reminder. The Bureau routinely has to wrestle with inconsistencies in an investigation. Remember this, both great employers and bad employers have complaints filed against them with the Bureau. The Bureau understands this. The Bureau has a job to do, and it will treat all participants with respect. Also, if you are being asked to provide information inside of an investigation that you don't think is relevant, talk to us, tell us why, and we can work with you. We might even agree with you after you explain it to us. Fifth, don't be afraid to ask questions. The Bureau is not the gotcha people, and we don't hide the ball. We work very hard to be transparent with the parties throughout the investigation. And last but certainly not least, do not forget your option of mediation or voluntary resolution. The Bureau has trained mediators to assist parties in reaching a voluntary resolution to a case as long as both parties consent to enter into mediation. Participating is completely voluntary and free, and you're not obligated to reach a settlement. If you're unable to reach a voluntary resolution, the case returns to the investigator to complete the investigation. The only impact entering mediation has on the case is that it extends the deadlines of the administrative process a bit. For example, if you are not successful in reaching a settlement in your complaint and it returns for an investigation, the investigator will have an additional 45 days to complete the investigation. You may wonder why the Bureau offers free mediation services and why a party would want to participate in such a program. Well, ultimately, the Bureau's voluntary resolution program can save parties time and money and provide an educational opportunity. The Bureau can begin mediating a case before the investigation even begins in some circumstances. Also, the time frame for investigating a case is 6 months, and continuing on with the administrative process and litigation can take upwards of 18 months to 2 years. So if the parties are able to reach a resolution, the administrative process stops, saving the parties the time and energy of that lengthy process. Furthermore, mediation is an opportunity for the parties to educate themselves not only about the case they are embroiled in, but also about how to avoid future discrimination cases. Would you like to learn more about the Montana Human Rights Bureau and what it does? Please visit our website at www.montanadiscrimination.com or give us a call toll-free at 1-800-542-0807 or locally at 406-444-2884.